Welcome everyone, and thank you for joining us today on Level Up Law. You can join us live every Tuesday at noon to level up your legal knowledge on the different areas of law that we handle here at South Carolina Legal Services. I'm Senior Staff Attorney Susan Ingalls, and I'll be the moderator of the webinar today with help along the way from our producer, Kenneth Elliott, from the South Carolina Legal Services IT Department. We are joined by Staff Attorney Elizabeth Abel. Elizabeth has handled domestic violence and physical abuse cases and worked on them in both criminal and family court. She'll be explaining for you how such cases are handled in family court versus criminal court in South Carolina and how to distinguish between the two. Elizabeth is also joined by our top-notch paralegal, Molly Morris, who will be also joining her to provide this information to you today. We do ask that everyone keep in mind that this is only general information for the public and not legal advice. For any specific legal issues you have, always consult with an attorney. During today's webcast, all attendees will be in listen-only mode, so be sure to put any questions that you have in the question box, and we definitely invite you to do that. Finally, as always, the webinar is being recorded. The recording and the slides will be posted on our YouTube channel for South Carolina Legal Services later this week. The description below will have links and documents provided by Elizabeth and Molly in their presentation today. Also, information about how to apply for free legal assistance at South Carolina Legal Services will be provided at the end of the presentation. Again, thanks so much for joining us. And now here are Elizabeth Abel and Molly Morris. Take it away.
Thank you, Ms. Ingalls. We appreciate it, and we are glad to be here. Molly and myself work up in our Spartanburg office, so we are hopeful some of you guys are tuned in and watching us. As Susie said, there will be time for question and answer, so please feel free to type any questions you have in the chat box. So as Susie said, my name is Elizabeth Abel. I wanted to kind of give a little background. I have been practicing law for 6.5 years now. I clerked right out of law school, and then I was a public defender for 5 years down in the 8th Circuit in Greenwood. I am fairly new to legal services up in Spartanburg, but I'm enjoying the work here. Certainly still feel like I'm helping a lot of folks. But all that is to say, I am still learning as well. So I thought this topic was interesting. If I've seen anything in my time here, it's that these arenas overlap a good bit. So I thought it may be important to kind of point out how things can work together and how things can be exclusive and stand on their own when it comes to domestic violence. And Molly has become a good friend of mine. We work together. She has been in the legal field doing this type of work for about 5 years, so she's been a great help. All right, so we're going to do a couple polls today. The first one we want to do, just to kind of start off and get the ball rolling, get people thinking, is who believes domestic violence is prevalent in pop culture? So you're going to have some answers. I believe Kenneth will put those up on the screen for you, and we will give you a minute to answer those. Okay, so Kenneth, you may need to help me out here. Where do I see my results? Uh-oh.
Elizabeth, if you don't see them yet, it's very prevalent, 42%, prevalent, 50%, maybe 8%, not at all, 0%.
Okay. Yeah, can y'all still hear me? I lost one of my
Yeah, we hear you. We hear you. You're good to go.
All right. Okay, so let's see here. So yeah, I mean, I think unfortunately domestic violence is pretty prevalent in our pop culture and in our lives. We may not realize it, but it is out there. So one of the, when I sat down to do this presentation, one of the things that kind of popped out to me that I remember as maybe being one of the first incidents I remember of domestic violence was this next slide. And bear with us, this video didn't play very well, so I'm going to pull it up on a separate screen. But just watch this and see if any of you guys remember this happening. So I'm sure some of you do remember that. That was back in 2014. That was Ray Rice and his then fiance. They did ultimately get married. He was an NFL player, I believe for the Baltimore Ravens. But I just remember that kind of blowing up on the internet. I mean, it was such a terrible video. Everybody was kind of talking about it and remembers that happening. So I think it kind of sets the stage for, you know, we see domestic violence in pop culture. We see it on our screens, on our news. You hear about celebrities all the time. Another most recent, Chris Brown and Rihanna, we've all heard about that. Ike and Tina Turner. Christina Aguilera has come out and spoken about the domestic abuse her mother endured. There are TV shows. A lot of us may have watched Snapped. That's an older show that's been on a while now, but it all, you know, points to this ongoing problem and issue that everybody seems to have experienced in one way or another, which is domestic violence. And I think it's important to realize, you know, it's almost glamorized sometimes, given that the attention is on TV. But we have to remember that it's affecting everyday people just like us, and it is prevalent out in our communities. Molly, give me a head shake. Were we able to play those songs during the poll? No? Okay. Do you have them? Can you play them now? Okay, so I got this idea from someone else, so I can't take full credit for it. But if you just Google songs with domestic violence, some of these just come up on the top of my head. But Love the Way You Lie is a really good one with Eminem and Rihanna that depicts a couple, and I think we'll play a clip of that.
I think Kenneth needs to share my screen for me to be able to do the songs, I believe.
Until the night, great one night, you depend on her mom. His love, deeper the city with the girl far away. To you, Dad, this isn't her every day.
Did you want to hear a different one, Liz?
I think those are good. Thank you. Okay, so I think we're back. Again, purpose of that is just kind of show, this is all around us. It's depicting everything in music from, couples going through the cycle, love the way you lie, you think it's going to get better, it doesn't, and it's just a vicious cycle. The Little Girl was the second song that was played, and it tells the story of a child who, witnesses domestic violence, endures it, grows up in it. Ultimately, her father winds up taking the life of her mother and himself, and she is taken, into protective services, and is ultimately adopted. So it's everywhere. Our purpose with legal services in these presentations, as Susie said, is we just want to provide basic information, educate the public, give people more knowledge. And hopefully it's helpful, if someone needs it. This is not geared towards lawyers. So if people are out there thinking, oh no, maybe I'm not supposed to be watching this, it's more legal. That's not true. We're wanting to offer everything we can for everybody. So appreciate everyone being here. Our second poll, I do want to preface with, nobody knows your answers. Everything stays confidential. And so feel free to answer if you feel comfortable. You certainly do not have to, but just to kind of see where we are, our second question is, have you or someone you know been affected by domestic violence? Okay, and now I'm having the same issue. I'm not seeing any results. If anybody could help me out.
Okay, well, the answer, oh, go ahead.
Yeah. I was just going to say it was 93% yes, and only 7% said no.
Okay.
So I think that goes to show, it affects everyone we know.
All right, so let's see if we can. Okay, we're back to my screen. All right, good. Yeah, again, I appreciate everybody answering. It's very upsetting, but I think it's important, that we do realize that it's out there. Everybody just about has seen it or heard about it or endured it, grew up with it, or maybe even committed it at some point. And it's just important that we recognize this, that it's ongoing, and that there are ways we can educate people to benefit everybody. So before we really dive in, just kind of want to go over the definition of domestic violence and just kind of, confirm what we are talking about today. So if you just Google domestic violence, Wikipedia says it is violence or other abuse in a domestic setting, such as in marriage or cohabitation. One of the biggest cases in South Carolina Family Court when it comes to physical cruelty defines it as actual personal violence or such a course of physical treatment as endangers life, limb, or health and renders cohabitation unsafe. And then our criminal code defines it, domestic violence, as saying it's unlawful to cause physical harm or injury to someone's own household member, or basically offer or attempt to offer that injury, and basically can make good on the threat. So all of these kind of summed up into one are, there's some sort of physical assault or abuse between people who were romantically involved or still are romantically involved. So that's what we're going to be talking about, just to kind of clarify that. And it can be called physical cruelty, it can be called domestic violence, it can be called intimate partner violence. It kind of has all these different tags, but we're talking about, the abuse or the assault, the threat of the abuse. And when I was going through some of my notes for my presentation, one of my lovely coworkers gave me the idea that we may need to just kind of lay out the scheme of our court system in South Carolina to kind of better help people understand exactly what I'm talking about. So this does not include all of the courts of South Carolina, but the ones we're going to be talking about today. So on the left-hand side, you'll see family court. On the right-hand side, you'll see what I'm going to refer to as criminal court. So there are lower courts, which are magistrate court, city court, municipality courts. They can appeal straight up to circuit courts, and circuit courts can appeal to the Court of Appeals and the Supreme Court. Family court and circuit court are on the same level of court. Some people struggle to understand that. So I'm a visual person. It's better for me to be able to look at it. And then family court and circuit court, as I said, can both appeal up. So just so you kind of have that background knowledge to see where we are, we included that slide. So I think some people may have already asked a couple questions. I was going to knock some of those out before we really dive in. So I kind of want to first start out, and I'm going to ask Molly a question. So Molly, some people may be wondering with this presentation, are we going to be providing any sort of resources for victims of domestic violence?
Absolutely. And we actually came across a website that you can go to that's very helpful, that will give you a list of domestic violence shelters in your area. It's domesticshelters.org/help/SC. And we'll provide that link to you later in the slide. But all you do is type your zip code in there, and it will list out all the places in your area that you can go to.
Thank you, Molly. Miss Susie, were there any other questions at this time?
No, right now we don't have any new questions. Thanks for checking in.
Okay, sure. All right, so we are going to go straight in. So I'm first going to talk about domestic violence in our family court arena, and then our criminal court, and then kind of how the two can overlap. But I do want to say first off, just because there's some sort of physical abuse allegation in family court doesn't mean that there's a criminal charge on the other side. And just because there may be a criminal charge doesn't mean there's anything going on in family court. So keep that in the back of your mind. Just because they can work together doesn't mean that they all the time do. So in our family courts, you think about domestic violence and physical cruelty is what we call it in a divorce setting. But it kind of comes up more so in divorce. Physical cruelty is a ground for a divorce in South Carolina. There are only 5 grounds. And as I mentioned earlier, it is defined in that Brown v. Brown case as actual personal violence or such a course of physical treatment as endangers life, limb, or health and renders cohabitation unsafe. So to break that down a little bit, there are just a few rules of thumb we can kind of go by when it comes to physical cruelty in a divorce setting. Typically speaking, there has to be more than one incident of domestic violence. So that can be, a few incidents, or it can be, a marriage of small history of, a history of small incidents. And basically our courts have told us that it's a case-by-case type basis that we have to look at. But the best rule of thumb is it's usually got to be more than one incident. However, our courts have also told us a divorce on physical cruelty grounds can be awarded if there's just one incident, but that incident has to be so severe and atrocious as to endanger life, or the act indicates an intention to do serious bodily harm or causes reasonable apprehension of serious danger in the future. So it's got to be a pretty aggressive incident for our courts to award physical cruelty ground for divorce. I also wanted to make the distinction here. Our courts in our state have said that an assault can be sufficient to grant a physical cruelty divorce. And what that means is a lot of times people hear assault and they think that's actually like the touching. An assault, the best way I've ever heard it explained in law school was, you rear back to punch somebody, that's the assault, the actual threat. When you make the contact, that's the battery. So in this case, an assault is sufficient if somebody is truly scared for their life and there's some sort of indication of an intention to cause serious bodily injury. So I think it's important to note that. Also, with the physical cruelty ground of divorce, a lot of people talk about, well, you have to do a year separation for a divorce in South Carolina. There are other ways to do it, but typically, you do the year. Technically, by law, if there is a fault ground to divorce, including physical cruelty, a final order for a case can be issued by a judge 3 months after the original complaint is filed. However, I feel like that is rare, because in family court, you're typically dealing with other issues and not just the divorce. So while it's technically true for people to say, well, you can do it quicker other ways, it usually doesn't work out that way. Another way that physical cruelty comes up in the family court arena is through orders of protection. Orders of protection are orders that are signed by family court judges, and they basically do what they say they're going to do. So it's a piece of paper that says whoever the defendant or the respondent is cannot harass, abuse, molest whoever the petitioner is. So what that means is the plaintiff or the victim. Again, these deal with household members. So as I said earlier, that means somebody that you have a child with, somebody you're in a romantic relationship with, you live together, or you have in the past, okay? Orders of protection can protect the actual adult who petitions for the order of protection, but it can also include any minor children the parties share. To get an order of protection, somebody has to petition the court. And what that means is you're filling out paperwork that's called a petition, and you file that with your clerk of court's office. If you actually just Google South Carolina petition for order of protection, it pulls up the actual court document you need to file. You can print that out, fill it out, and you take it and file it against the respondent who you're alleging is causing the physical abuse. Quickly, other things that
I want to jump in and say, as far as filing orders of protection, that's something that is our safe homes or abuse shelter can help you do as well. So if you did go there, that would be something that they would help you and assist you in filing that.
Yes, thank you, Molly. If you do file a petition for an order of protection, it's pretty self-explanatory. You go down that list of things that are listed in the paperwork, and there are other things that can be decided at an order of protection hearing. Those include custody, visitation of any minor children, any sort of financial support, and who can stay in the marital home if those issues are relevant. It's important to note as well, if there is a valid order of protection issued against someone and a judge makes a finding of fact of the abuse by the respondent, by the abuser, and puts it on the record, then they are prohibited from owning firearms for the length of that order of protection. And an order of protection can last anywhere from 6 months to 1 year. As Molly said, we are going to provide resources at the end of the presentation about how you can get an order of protection, how to fill out your paperwork. All of that will be linked later. So look out for that. And as I said, if you just Google that petition for an order of protection in South Carolina, the actual court form pops up. You can print it and fill it out. The next big way that physical abuse or domestic violence comes up in the family court arena is with custody in the Department of Social Services. I'm not going to get too in depth in this topic because, again, a lot of stuff is a case-by-case basis. But I think it's important to just know and have the knowledge that if there's any sort of allegation of physical abuse in a home, it is very, very likely that the Department of Social Services is going to become involved, okay? And that allegation can come from anywhere. It could come from somebody calling law enforcement, and law enforcement comes over and, you know, maybe arrest someone for domestic violence, or maybe they don't. They can still go to DSS and say, look, you know, I think that there's abuse going on. There are other people who are mandatory reporters, such as teachers, doctors, nurses, things like, or people like that, that, you know, if they suspect physical cruelty, they have to report it. So if DSS gets one of these reports, ultimately what happens is they make an investigation into the home, into the parents, to see if the children are safe. Everybody's goal is to make sure children are safe, and they may do that through putting in place safety plans with parents, may provide them, you know, education or classes, you know, maybe if someone needs some anger management classes to learn how to better, you know, maneuver through their anger, not take it out on mom or not take it out on kids, things like that. Those may be put in place if there are findings that, you know, the children are just unsafe and it's going to take a while for parents to gain that custody back. Children can be taken into DSS custody. And I think it's important to just note as well, you know, even if it's just a divorce and there's really not a DSS investigation going on, when it comes to custody, you know, I don't think it's going to fall on deaf ears for a judge if there are these allegations of some sort of abuse against children. Let's see, victim impact in family court. We're going to talk more about that in criminal court, but in family court, you should just be aware that, you know, if you file a divorce on physical cruelty grounds and later you come back and you say, well, you know, I don't want to do that. I don't want it in court documents that he or she abused me or whatnot. You can have it dismissed. That's not always necessarily the case in criminal court. So it's just much more voluntary in family court if you're going to go for physical abuse. General timelines in family court, as of late this summer, July 24th, 2020, our Chief Justice in South Carolina, Chief Justice Beatty, reissued an administrative order in family court saying most cases should be dealt with in 365 days. So it's kind of the guideline and the rule is that you have 365 days in family court to have a case resolved. Let's see. And as I said, he renewed that as recently as this summer. So I have listed the site for the Brown v. Brown case and then the actual laws, statutes, if you need to go reference those, if you want to go look those up, those are there for you. Now,
And
we're going to, yes.
Elizabeth, before you move on to criminal court, I know we had talked about resources, but this, I guess, isn't necessarily resources. These are more just tips if you're in the middle if you're dealing with abuse currently, some things that we have in a brochure that we like to give people. So if you're in an abusive relationship, some things that you can do to help yourself and your children. Teach your children how to call 911. That's always, that's never a bad thing for them to know how to do. Create a code word so they know when you need help. Keep important phone numbers for law enforcement, shelters, friends, and family. Just keep those handy so you always have access to those. Know the locations of nearby safe places. So that would be where the website that we mentioned, you could go in and you know where those facilities are that you can reach out to. It's important to tell your family, friends, neighbors about the abuse. Ask them to call law enforcement if they hear violent noises or know something's going on. Make an escape plan for home and work. Invest in a cell phone, maybe not necessarily, maybe an additional cell phone. If you have those resources to do that, it's always good to open a credit card or bank account in your name only, that only you have control over. And then if you get to the point after you've done all those things and you consider leaving, have multiple places. So identify more than 2 places that you could go. Try and think of different people who could help you, who could loan you money, who could keep your belongings, and that's stuff that a safe home could help you with. Keep bags of items packed. That way, if you needed to grab them in a hurry, that's ready to go. Consider what you should do with your children and your pets. Would they be safer with you, or would they be safer with a loved one? Would it be safer to stay in safe homes versus with a family member where, this person may know where you are? Think of different excuses that you can tell your significant other why you need to leave the house, such as walking the dog, going to the grocery store, or even just taking out the trash. It's important to make extra copies of your house and car keys, because that's, a leverage thing. I'll take your keys, you don't have access to these anymore, but that's something good to keep copies of that they don't know about. Be familiar and review your safety plan and practice it step by step. That way you're not worried about what you need to do. And if you're in a situation where you've already left, these are some tips that you could do. Continue to monitor your safety. And that's a case-by-case thing. You know that your significant other better than anybody, so you know the things that you need to be worried about. Consider filing for an order of protection or a restraining order like we had talked about earlier, and that's something, again, legal services helps with, but the abuse shelters help with as well. If you do get one, it's important to keep copies, especially if it addresses your children. You give those to the school, you keep those in your car, you have them with the daycare. That's something that you always need to have on hand, that you can give out to the people that need to have it. If you are able to get back in the house, change the locks. That's important too. Give your friends, family, and neighbors a picture of your abuser if they don't know who that is. Say you move to a new place, maybe they don't know who that is. Make sure they know who it is so they can keep an eye out for you. Again, even though you've already left, still ask your friends and neighbors, to call law enforcement if they see you're the abuser near your home. Tell your children's schools and caretakers who's allowed to pick up the children, which again would go with the order of protection. They would say that they're not able to pick up the children, but if it's not, talk to the schools about who's allowed to pick up your children. Ask a coworker to screen your calls if they might be calling from work, trying to get in touch with you in a different way. Use different stores and driving routes than you've previously used, so try and keep a different pattern to where they are not going to know where you're going. Find a support group or a counselor, and again, that's something that Safe Homes could help you with. DSS, if they happen to be involved, that's something they can help you with. And an important thing, especially if you have children, is to find a safe way to communicate with your abuser if you have to. And again, if you have children, you're gonna more than likely you're going to have to communicate in some way, shape, or form. There are different parenting apps, some that cost, others that don't. I believe there's an app, it's called Talking Parents, and it's free. And what that does is it documents all your communication. It records your phone calls. It keeps up with text messages, dates, and times. More specific than your cell phone would, and it's all in one place. And not to get too much into it, but if you were in a court case and a guardian was appointed, that's something that they could have access to. So that would be important to help communicate with them. But I just wanted to take a minute to make sure I gave you those tips before you moved on to the criminal part of it. But those are some things you could do to help.
Thank you again, Molly. As everyone can see, Molly is a great resource in and of herself, and she is a huge help and benefit to our clients up in Spartanburg. So we're going to move on to criminal court. A couple things to note before we get into domestic violence and the nitty-gritty. Our domestic violence statute was rewritten in South Carolina end of 2014 and actually became effective June 4th, 2015. So that's important because sometimes people will still say criminal domestic violence. Sometimes people say domestic violence. Well, in 2015, everything switched from criminal domestic violence, and it went by your number of offense. So it would be like CDV, first offense, second offense, third offense, and it went up. Well, now when they rewrote the law, it more or less mimics our assault and battery law, and it's called domestic violence, and it goes by degrees, and it goes up third, second, first. So the numbers are opposite when they rewrote the law. So that's important to note when talking about the criminal conviction side of it. Another couple differentiations to make. When I originally started talking, I showed you our court map and our court scheme in South Carolina. General sessions is sometimes called big court. Magistrate and city court are called lower court sometimes. So again, that's kind of where that original slide came in, was just to be able to differentiate which court you're in, but they're both criminal courts, or can be. So when we talk about domestic violence in the criminal arena, there's really only one domestic violence charge that can be initiated or brought in magistrate court or lower court, and that is domestic violence third, and that's where we're going to start. So domestic violence third is basically that basic definition we talked about earlier. It's unlawful to cause physical harm or injury to a household member, or offer or attempt to cause the physical harm or injury. So that's our base level for domestic violence in South Carolina. That is the actual third degree. And as I said, that can be brought in magistrate court. It can be written on a uniform traffic ticket. That was a new part of the law a few years ago. It doesn't have to be on an arrest warrant. And it is a misdemeanor that carries up to 90 days. So what that means is it carries county jail time up to 90 days. You can be put on probation for domestic violence third. However, you would only have the 90 days above your head if you were placed on probation. And I do need to note that although domestic violence third can be brought in lower court, solicitors now, prosecutors can bring it up to big court. So it still carries the same amount of time, but it can be heard in general sessions. And I guess I should also note as well, if I say solicitor, for anybody who's listening that may not know what that means, that is the state actor in criminal court, the prosecutor or the district attorney. I think South Carolina is one of a few states left that still uses the word solicitor. So that's what I mean by that. So the base level is the third degree, and then you bump up to domestic violence second degree. Again, it is the base element, the third degree, and then there's another aggravating circumstance or aggravating factor. So All of these are going to be listed in bullet point form. They're on an outline that should be linked to this presentation on Legal Services YouTube page. If you want to see it, if you're more like me and a visual person, it is listed out with the elements. I'm going to just hit some of the more common ones. So for domestic violence second, I saw it more so with the DV and then a moderate bodily injury. What that means is if there's a moderate bodily injury, typically the rule of thumb is that's like a broken bone or, you know, a pretty severe cut or something like that, but something that can be healed and mended and you'll be back to normal. So typically you see moderate bodily injury or a child was perceiving the event. That's important here to say that just because, you know, somebody may say, well, the child was home, but they didn't perceive it. I mean, judges have told me that's not true. If they hear it or witness it, you know, or see the aftermath of it, a judge can consider that as perceiving it. So a jury may too, and prosecutors certainly do as well. And another common aggravating factor is that there was a broken cell phone because of the incident. Someone's causing the abuse, the domestic violence third, and basically, you know, prevented someone's access to calling law enforcement for help. Domestic violence second degree is a misdemeanor, but it is also in general sessions court. It has to be heard in general sessions court. It's in big court. And it carries up to 3 years in prison. So another misconception is, oh, well, it carries more than 30 days or more than a year. So, you know, it can't be a misdemeanor, and that's not true. It's still considered a misdemeanor, but it does carry 3 years in prison. And it can also be written on a uniform traffic ticket. I had several clients in my days as a defense attorney argue with me about that. They don't have to have an arrest warrant for a domestic violence second. It can be on a traffic ticket. Moving on, you then go bump up to domestic violence first. And it, again, is the base level DV third, and then you have more aggravating factors. So, well, let me back up. Before we get to those factors, there's a pretty big jump from domestic violence second to a first degree. The biggest differences are it's a felony, it's a violent offense, and it's a serious offense. So you go from a misdemeanor to a violent, serious felony. And we can talk about that in a little bit, but I did want to start out with that. So you have the base level DV third, and then some of the most common aggravating circumstances or factors are there was great bodily injury, which again, rule of thumb for great bodily injury as opposed to moderate bodily injury is, you know, something has happened and, you know, it may be able to be fixed, but it's never going to be completely right again. So say maybe someone was cut and, you know, they had an organ that was affected and it's never going to be back completely right. That could be considered great bodily injury. They had 2 prior DV convictions in the last 10 years. That's probably the most common way I have seen domestic violence first. You committed domestic violence third, but you have 2 priors, so it's automatically up from the misdemeanor 90-day DV third to a violent serious felony that carries 10 years. A firearm was used, that automatically can bump it to a first. And then again, if you can get to a domestic violence second without any of the aggravating factors there, in domestic violence first, if you have a DV second plus an additional aggravating factor, it can make it a first. So these statutes are pretty technical with all of the factors that can go into them, and those are listed out for you in that outline. So if you want to take a look at that, feel free, but I'm just, again, trying to hit some of the high points. As we said, it's a felony, it's violent. What that means is if you are convicted and face prison time on that conviction, you'll be placed on a violent prison yard. Sometimes people hear violent and they automatically assume that means 85% time, meaning you would have to do 85% before you became parole eligible. That is not true. That is not what violent means. It's only 85% time if a crime carries 20 years or more. Then we bump up to a domestic violence high and aggravated in nature. I have listed, it is a separate statute. It is 1625-65, and I've listed those on this slide for anybody who wants to go back and look. But again, you have the base elements of, a physical abuse or attack, or the present ability to do so. And then there are more aggravating factors. So you commit the offense under circumstances manifesting extreme indifference to the value of human life and great bodily injury results. So again, we have great bodily injury here. Commits the offense under circumstances manifesting extreme indifference to the value of human life and would reasonably cause a person to fear imminent great bodily injury. So again, it's enough that you actually fear the great bodily injury. You don't have to actually have the great bodily injury. Or there's a deadly weapon, you impede someone's airflow, there's a child, a victim is pregnant, it's in the commission of a robbery, burglary, kidnapping, or theft, and again, you have a broken cell phone. Again, this is heard in General Sessions Court. This has to have a warrant, as well as DV First has to have a warrant. And it again is violent and serious, but domestic violence high and aggravated carries up to 20 years in prison. Bumping on down, in South Carolina, when they rewrote the statute, they gave circuit court judges the ability to issue permanent restraining orders. Those are similar to orders of protection. Really, the only difference is it's in criminal court. A circuit court judge signs it, and they can last forever, hence the name permanent restraining order. It's basically up to the judge's discretion how long they last. So a judge can make it last forever. They can say 0 to 5 years, 0 to 10 years. For a DV hand conviction, I believe it has to last forever. That may be wrong, but it can last for that length of time. And I will just say the penalty for violating a permanent restraining order is a felony that carries up to 5 years. The penalty for violating just regular restraining orders from magistrate court or orders of protection and family court are less. They are misdemeanors that carry 30 days. So this, if you violate this, carries much more time. Also important to note, any sort of domestic violence conviction in South Carolina carries with it the possibility of not being able to own or possess or sell or transfer firearms or ammunition. The amount of time you can't own that firearm is determined by the conviction on your record. But the best rule of thumb is to just not have one. And you should also remember that there are federal laws that come into play as far as domestic violence convictions and firearms as well. To kind of wrap up, I'm trying to be quick, we're running out of time. A couple things to be cognizant of. Anytime you're in criminal court and someone is convicted of domestic violence, there are certain special probation terms that go along with their sentence. So if they get probation, it's reduced all the way down, then there are certain things that they have to sign on probation and certain classes they have to take, certain conditions they have to abide by. If not, then they're in violation of their probation and can be rolled back into the court for a rule or show cause hearing for a judge to decide if they are in willful violation of that probationary sentence. Another important condition that I wanted to talk about as well that goes along with orders of protection and restraining orders are bond conditions. Anytime somebody is charged with a criminal offense, they are given a bond. Most of the time, if it is an underlying domestic violence issue or charge, a judge will put on their bond conditions, hey, you don't need to go around her, or you don't need to go around him. Stay away from there. I don't want you 5 miles near their house. I don't want you going to their church. I don't want you talking to them directly or indirectly. That means I don't want you, talking to their mom on Facebook, telling her to tell him this. That's another important thing to point out, just because, you know, even if you have the order of protection, you know, if they're charged as well in criminal court and they have those bond conditions, if they violate those bond conditions, you know, then you can go talk to the prosecutor and say, look, they're messing with me, they won't leave me alone. And they could potentially be looking at a bond revocation hearing and wind up back at the detention center. Timelines, again, everybody shoots for the 365-day mark. That's kind of the rule of thumb in South Carolina. Criminal court can tend to go a lot faster or a lot slower. I think it kind of depends on where you are, the resources available in your county, the seriousness of the allegations, you know, people's personal criminal records, things like that. So if it's an easy case, it might move much more quickly than family court. If it's a much more difficult case, you know, great bodily injury, things like that, it's going to take a while, then it can take longer. So I promised we would also talk about victim impact. And I believe one of our pre-submitted questions asked about victim impact in criminal court. If someone calls law enforcement and someone is arrested and charged with a domestic violence crime, the alleged victim can sign an affidavit not to prosecute with the solicitor's office. What that means is they're kind of throwing their hands up and they're saying, well, this happened, but you know, things are better now. It was a misunderstanding, and I don't want this to go forward. I don't want this prosecuted. I don't want to be part of this. At that point, a solicitor could dismiss a case, but in South Carolina, they do not have to. Once a charge is in the solicitor's office and it is being prosecuted, they can go forward through until a resolution of the case. So that's in the prosecutor's discretion. That's important to know. And again, you know, in comparison with family court, like I said, it's much more voluntary in family court because you can just withdraw the case. Whereas in criminal court, of course, you need to call law enforcement and you need to let everyone know what's going on if you are a victim of domestic abuse. But if you change your mind later and don't want someone charged, don't want them in jail, at that point, it is no longer in your discretion. And again, I've listed general provisions of our domestic violence statute, the specific domestic violence high and aggravated, and then the firearms prohibition. Quickly. So we said originally, you know, you can have abuse in family court and it not be in criminal court and vice versa, or you can have them at the same time with the same people. It just depends. A few things to just realize and recognize. An order or a conviction in one court could affect the other court. Like I said, if you have an order of protection in family court, but there are also criminal charges, look for those bond conditions. Look to see if you're protected both ways. In criminal court, if you do have the charges, you want a permanent restraining order, see if you can get an order of protection too, if you think you need one. All of these are out there, and the law was rewritten to, you know, to have these safety nets and all of these levels and layers of protection. Victim services, one thing I wanted to point out, in South Carolina, in my experience as an attorney, you know, sheriff's departments have their own victims advocates, solicitor's office have their own victims advocates. They are all willing, you know, and hopeful to help you. So reach out to them, especially if you know, are a victim in the criminal arena. Let them know what's going on. Let them know if, you know, if that abuser is talking to you and, you know, not abiding by those bond conditions, if they're not doing what they're supposed to do. Reach out. These people are here and it's their job to help. And, you know, 9 times out of 10, that's what they're going to do, and that's what they're going to want to do. So reach out to them. Other victim services we'll talk about on our resource slide, but as Molly mentioned, there are safe homes throughout our state. We listed the website that Molly already mentioned that will, you just type in your zip code and it pulls up everything near you and around you, and it's really great. So I will leave that there. But another thing, hearings are under oath. So this Smith v. Smith case I put on here is a 1987 case, so it's a little older, but it basically said a guilty plea couldn't be used against someone in family court. It's important to remember, though, that if you are testifying in family court or criminal court, everything you are saying is under oath, everything is recorded, and it could potentially be used against you later, especially if you take the stand in the other court. You could possibly be impeached with those prior statements. So keep that in mind. Lastly, again, excuse me, we are, everybody's goal is to ensure children are safe. I hope that's everyone's goal. Children are affected. It doesn't matter if you're in family court, criminal court, magistrate court, city court, whatever, what have you. If you're not in court at all, domestic violence is out there, and these children are witnessing it, and it affects how they grow up. It affects, their learning and their abilities, mentally and physically. So I think we can all agree on that. Again, courts, they are not exclusive. They can be exclusive and they can also overlap, but just because you have a conviction in criminal court doesn't mean you'll get the physical abuse finding or order in family court and vice versa. So, all right, we have talked way too long. Whoever's still here, I appreciate you. So again, we've listed our resources here. These will all be available to go back and look at later. The domesticshelters.org/help/SC is what we have mentioned several times. Our legal services link, brochures will be linked. There's going to be one, like Molly talked about safety plans and having those things in place, as well as what exactly is an order of protection and how you get one of those. There's a really good packet that's going to be linked. And one of the last pages of that packet actually list county by county all of the safe homes. So that's another good thing to look up. Again, call your sheriff's department, call your solicitor's office, ask to speak to those victims advocates. They are there, and I'm sure can also add to this list of resources. All right, Susie, I think we are ready for questions now. I don't know if we've gotten any more, but.
Yes, ma'am, we have 2 more questions. Oh, go ahead, Molly.
No, I was going to follow up. I know that I think the ones that we've been asked that we haven't addressed yet is how do you combat someone that secretly destroys or sells property and then they deny that they've done that? Elizabeth and I talked a little bit about that, and she can say the same. It's I guess to necessarily avoid that would be to document as much as possible. Take pictures of your property. If that's a concern of yours, then do everything you can to prevent it. So take pictures, make sure other people are aware of this property, hide it if you can. But it's best to show it on paper, that it exists. Do you have anything to add to that, Elizabeth?
Yeah, I'll just add, again, I think that goes for both court arenas, family court or criminal court. I was just going to add, like you said, document. And as far as family court's concerned, the order of protection hearing can provide for some of that. Actually, one of the boxes you can check is to ask the judge to prevent the respondent, basically order the respondent to not destroy any property. And then if you're going through a divorce, a judge will do what's called an equitable distribution and go through and, decide who's going to get what marital property. So that will take place, but originally, in the beginning, the order of protection is probably the best way to go. And I will note, as far as criminal court, if you're not married, and even if you are, if it's personal property, there are charges if somebody's maliciously damaging your property that could be brought. So again, if you think it's criminal in nature, call your sheriff's department or local law enforcement agency. And one of the others that was previously sent in, I believe I've addressed, is South Carolina allowed to drop someone's domestic violence charges if the victim is being pressured into signing an affidavit. So we did talk about this, but I do want to add on, you know, if someone's being pressured, a victim's being pressured to sign an affidavit not to prosecute, my best advice is go straight to that solicitor's office, straight to that sheriff's department. You know, if you have text from somebody threatening or, you know, offering to pay you to sign it or what have you to drop the charges, you need to let them know that immediately, and that could ultimately they could ultimately bring more charges, because that is a criminal offense. You can't witness tamper or threaten anyone in that nature. So that would be my advice there. And the other one,
I think the other,
go ahead.
well, I was going to say the other question was, are there any restorative justice programs happening currently in South Carolina for IPV cases?
Okay, so like we said, IPV is intimate partner violence. Restorative justice, what I'm assuming that means is kind of comprehensive type programs to better oneself. So really my best answer for that would be that through criminal court, you know, you do have the batterers treatment programs. There are plenty of private programs run through churches and people within communities that offer advice and, you know, programs that help people learn how to sort through their anger, sort through their emotions, and people complete those all the time. So those are out there. A lot of times they'll be ordered, you know, if there is a domestic violence conviction, like I said, through probation. If someone's on probation, they'll be ordered to do those treatment classes. But a lot of times people can go and do them on their own, and it typically looks a lot better if somebody takes that initiative and does that. In addition, I would just say DSS, you know, we touched on that slightly, but DSS offers plenty of parenting classes, you know, and have alternative resources for just helping folks learn to better control themselves. So I'm hoping that's helpful. I'm not sure I answered the question, but that's the best I can do right now.
Well, let me take this opportunity to thank the two of you, Elizabeth Abel and Molly Morris, for an excellent presentation. Elizabeth, if you can go to the next slide so our viewers can see the contact information for South Carolina Legal Services. This was really great information that you all provided on these intersecting areas of law. It's so important for people to understand what the distinctions are. Let me also thank everyone who joined us today. We truly appreciate that you joined us, and we thank you for your interest in this subject matter and the others that we share in this Level Up Law programming. I want to be sure everyone knows that Level Up Law is a series of free webcasts provided by South Carolina Legal Services on some of the most commonly faced legal challenges that we see here. We're live every Tuesday at noon, and you can find this and all of the previous Level Up Law episodes going back to June of this year on our YouTube channel. Just go to YouTube and search South Carolina Legal Services and click on the playlist for Level Up Law. Be sure to give us a thumbs up if you found this helpful, and I'm sure you did, and do subscribe to our channel and sign up for those alerts. Give us a day or two to get this episode uploaded, and then you can listen again for anything that you might have missed. All right, now if you have an issue and you need legal assistance and cannot afford a lawyer, you may be eligible for our free legal representation, and here's all the information that you need on the screen. Our intake office personnel are standing by for your call 9 to 6, Monday through Thursday, so be sure to call in and apply for our services if you are in need. Again, thank you for tuning in to Level Up Law. We do hope you'll tune in next week when we'll be talking about the latest developments in the Fair Debt Collection Practices Act. So to see what's coming up each week, check out our Facebook page, or you can follow us on Twitter and Instagram, which you see here on your screen. Again, thanks Molly and Elizabeth for a great presentation. That concludes today's webinar, and we look forward to having everyone back with us next week. Thank you.
Thank you.